Hi, and welcome to the Acuity Law Sector Update. My name is Jenny Wild, and I'm a partner in the Health and Social Care Regulatory Department here at Acuity Law. I'm joined today by my colleague Sabina from our Immigration Department to discuss some of the changes in immigration law that are inevitably going to impact the health and social care sector. We thought it would be useful to sit down, discuss the main issues, and highlight some points that providers of health and social care services should be aware of. So hi Sabina, do you want to tell us all a little bit more about your role and what you do at Acuity?
Hi Jenny. Yes, so I head up the immigration department at Acuity, and we deal with all forms of immigration cases, and specifically tailoring to the corporate clients and complementing the clients Acuity has. And we have a crossover with our healthcare department. So we support with that in terms of care homes, dental nurses, etc. And some of the updates we'll be bringing you today crossover and overlap with those areas.
Yeah, and there have been loads of changes over recent months that are coming in the future. And I guess the idea of us sitting down and chatting is to, as we said at the top of this discussion, highlight to people what those changes are, when they're coming into force, and how it might affect their business. So could you give us an overview, Sabina, of the changes that are happening imminently?
So the government had announced in December last year that they were looking to reduce overall net migration, and some of these changes have actually been put into force quite quickly. So one of the very first ones in January, on the 1st of January, they put forward a change whereby students are no longer able to bring their dependents into the UK, and that's supposed to cut down on a lot of applications that are made. So if there's students that are already in the UK or have pending visas that are valid past the 1st of January, they're able to call their student dependents over, or they're able to continue to sponsor dependents. However, anybody who's applying after that date, and they're currently not able to do so. There was also a change to the rules just before December as well in relation to the students, whereby previously they were able to switch from the student category into a skilled worker category, even if they hadn't completed their course of study that they'd entered the UK for. But now it's a legal requirement for them to have completed, and by completed we mean passed their exams and finished the course before they're able to switch into a skilled worker category. So I think that will actually affect a lot of people that previously were thinking, okay, maybe I'm not going to finish my studies, but I'm able to find suitable employment and I will go into that role. Mm-hmm. There's also on the 11th of March changes coming into place whereby healthcare workers, more specifically care workers and senior care workers, are not able to sponsor their dependents any longer either. So I think that will have quite an impact on the healthcare sector, because we have a lot of healthcare workers that are actually female, and they do have children and they have partners, and where they've previously been able to support them and bring them into the UK, if they make applications on or after the 11th of March, they'll no longer be able to do so. But with the transitional arrangements, if they are already in that route, so if they've already secured a skilled worker visa, and their children and partners are with them, they can continue to extend and support them. Or if they are already in that route and have children or partners abroad and they want to bring them over as dependents, they're still able to do so. But like I said, if they're making applications on or after that date, they'll no longer be able to do that. But the other healthcare workers, such as dentists, your dietitians, your doctors, your nurses, etc., they are still able to continue to sponsor dependents. And I think one of the big changes, Jenny, is on the 6th of April onwards, there's an increase to the salary thresholds for skilled worker visas. And at the moment, the minimum threshold is £26,200. So that's what you're expected to pay employees as a minimum threshold on that visa. That's due to go up to 38,700, which is quite a jump. And that change is also reflected in the partner visas. So they're doing it in small increments, but eventually by 2025, they're looking at having the spouse visa route plus the skilled worker route. The salary threshold will be fixed at the 38,700. So I do think that's going to actually have a huge impact. It probably will help with the net migration, but I do think it will have a huge impact on the different industries, and especially, like I said, with the care workers and not being able to bring their families in.
And does the increase in that threshold apply to care workers at the moment, Sabina? Is that going to change now?
So the salary increase apply to the care workers. They are actually exempt from that, but there is a slight increment. So the Migration Advisory Committee was asked to do a rapid review of the what's called the shortage occupation list, to look at the routes that are on there and that are currently exempt from thresholds, etc., whether they should still stay on there. And the quick review that's come back, that was commissioned, has suggested that there should be a slight increase. I think it's to bring it in line with the national minimum wage, etc., in April as well. So it would go over just over 23,000 pounds at that stage, and they're removing what's called the going rate, which was an hourly rate, and it will now be referred to as a financial threshold as well. So whilst we're exempt from the increase to the 38,700, there will be a slight change to the amounts that we're paying at the moment, but there is a full review that's due, and they're hoping to implement it all by the 4th of April as well.
So wow, there are loads of changes, and I've seen and heard from clients that they believe that this might, although it's a diluted version of what's applying to other sectors, and there is that exemption that you mentioned, a lot of my clients are concerned that workers not being able to bring their families across will deter them from coming, because as you say, there are so many women in the sector, so many people that want to come along with their families, understandably. And we'll just have to wait and see how that impacts the sector, a sector that's already struggling with staff anyway. So there's going to be some kind of outcome there.
Yeah, I think the Migration Advisory Committee has recognised that there is a shortage in the healthcare industry, shortage of workers in the UK, and they're trying to preserve those type of visas. But I think if they're looking at net figures, and it is the fact that there are more dependents coming in, and that's where they see like a quick win to try to reduce numbers. But I can understand the reasoning behind it for purpose of reducing numbers, but when we look at the impact that it's going to have on the care industry, I think it's going to be huge. One of my clients who I was speaking to today, they are a care home, and they have over 200 healthcare workers working for them. So if some of them are no longer going to be able to stay, if for example, so they're not all on healthcare worker visas, but they're healthcare workers. So those clients are now getting in touch with them with the view to trying to switch into the categories before the 11th of March to try to preserve that for themselves. But it's going to be very difficult. So where you have care homes, etc., that are heavily reliant on migrant skilled workers, it will have a huge impact.
Yeah, definitely. You've just alluded there to the administration of visas, Sabina, and how difficult that can be for providers of social care services and healthcare services. Providers are used to dealing with a lot of documentation, having to evidence things to either the regulator or the local authority. But how can providers make sure that they're safely and effectively collating all of the relevant evidence for those overseas staff that they employ? How can they manage that?
Okay, so where the people or organizations are employing migrant workers, especially on the healthcare worker visa, they will need to be holding what's called a sponsor license. And along with the sponsor license, there's a lot of compliance duties and record keeping duties that need to be adhered to. Now, we offer support with that, but generally speaking, we're looking at across the board. So it's not just worker or visa related information that needs to be looked after and complied, but just generally with the organization itself. So organizations need to make sure that in order to keep their A rating sponsor license so that they're able to employ people. Any changes that take place to the organization, for example, if they are acquiring another practice or another service, or if they're demerging, for example, that these changes are reported on time. Even if they're sole traders are becoming incorporated, or if we're changing names, or we're changing legal registered addresses, all of these things need to be reported.
Mm-hmm.
And with the workers themselves, we need to make sure that all right to work checks, etc., are carried out properly, that all documentation is stored. So, and alerts in terms of when visas are due to expire, when people need to make sure that they are applying to extend their visas before the visas expire, so that they have that continuous right to work in the UK. And so I think it's really important to have stringent systems in place, HR systems in place, that ensure that all the document and record keeping is done properly, and that we're reporting any changes to the Home Office on time. And I'm sure this ties in with the CQC requirements as well in terms of documentation and record keeping.
It does. There are loads of responsibilities around staffing with the regulated activities regulations that providers of health and social care services have to adhere to, in particular regulations 18 and 19. So that's documentation of staff generally, and also employing fit and proper persons. All of that has to be evidenced and available. But in addition, I think it's really important to note for providers that CQC have implemented it's almost a new strategy on dealing with modern slavery. So anything that isn't correctly documented or seems to be outside the scope of the law in terms of visa requirements, the CQC don't have the power to investigate that themselves, but what they will do and have done is refer those matters on to the relevant bodies. And that can be very problematic for providers, especially if everything is legitimate, but it just hasn't been recorded properly.
Yes, I've actually done some training this morning with another organization that we were speaking to about the importance of right from the start, when we're taking on these employees, to make sure how job adverts and recruitment has taken place. So we got that evidence. We have come across over the last couple of weeks somebody who has been brought into the UK, who's been exploited for the money that they've paid in order to secure their visa, and there wasn't actually a healthcare worker job available for them when they entered. So to make sure that these type of people don't fall through the net, and that our organizations that we're working with don't get picked up for anything, it's really important right from the outset when we're looking at our recruitment strategies and our adverts, etc., and then collating that information. So if we've had applicants, make sure we've got their CVs, make sure that we keep interview records and marking matrix exactly to show that we've got the people that are actually qualified or have the relevant experience to be able to do the work, and how we've come across them. And even for the purpose of the skilled worker visa or the sponsor license, we have to show that there were genuine vacancies that were advertised properly. And unfortunately, the care industry has been recently in the press in relation to people that have been exploited. So it's really important, cannot state it enough how important it is to make sure that everything is above board. And I think another thing we'd come across was people issuing certificates of sponsorship for care worker visas at a certain salary and it being approved by the Home Office, but then when it's come to actually pay, the pay is not in line with that. And again, that's another form of the exploitation. So it's really, really important that we're able to show we're abiding by the CQC requirements, we're abiding by the sponsor license requirements, and then generally with employment law requirements, to make sure that we're not falling foul of any rules. And the best way to do that is make sure that everything is documented.
Absolutely. It's a stark warning, isn't it? I think that most providers would hate to be tarred with the brush of exploiting people when it's in their interests and it's their job to take care of vulnerable people. But the sector, unfortunately, has had some negative press. So in terms of those responsibilities around documentation and ensuring good practice, how is it, Sabina, that yourself and your team can help care providers. Now, I'm used to people having to document compliance in all of the regulations and provide this to the CQC at the drop of a hat. So they have those kinds of systems in place, and they've been doing it for years. Some people can feel a little bit overwhelmed with immigration law responsibilities and maybe don't have effective systems in place. How can you help them, and what would you advise?
So I'm going to say that with organizations that do have regulatory bodies and they are registered, they will generally hold most of the information that they will be required to use for immigration purposes anyway. It's just having that accessible and knowing what is required for each body, for example. Now, with the sponsor license, there are, like I said, a lot of compliance duties, and there's timeframes within which certain changes have to be reported. And with the smaller organizations, we offer training, so we can offer training and provide, checklists, etc., whereby if they're smaller organizations employing one or two workers, etc., it's easy for them to manage internally, and obviously we're there to support that. But for the larger organizations, we do offer services whereby we're able to manage the license for them. So we're able to check in with them on a regular basis, for example, on a monthly basis, ensure that there's no changes to be reported. If there are, then make sure that they are reported within the time frame, so we can be added as a level 1 user onto their license, and we're then able to report any changes on their behalf and make sure everything's done within the correct time frame. We also offer an audit service. So if you've had a license for a little while and you're not sure whether you're adhering to everything properly and you just want to make sure that everything's up to date, we're able to come in and review your records and review the record keeping systems that you have in place, the management systems, to ensure that they actually have all the information that's required for sponsor license purposes. And I guess it crosses over to make sure that all the correct right to work checks are done as well for non-skilled workers or non-healthcare workers as well, just across the board, to make sure everything's in place. So we're able to do an audit and advise in relation to that. And we also offer a subscription service whereby if it might be that you don't need assistance with it on a daily basis, but you'd like to be able to have handy somebody at the other end of a phone if something cropped up, and we're able to offer that as well. So if there's if you want to have a subscription whereby every month you have a certain number of hours, and that's down to the organization, they're able to agree that, and if anything crops up, we're on the other end of the phone to be able to address those issues and advise accordingly.
That sounds like a really good peace of mind, Sabina, and I think it's good to cover the bases that a provider might not understand completely, but be very aware that they have to get right. And I think having somebody like yourself and your team in the background to help with that would be really useful. So thank you for talking us through that.
No problem. Thank you, Jenny.
No worries. And everybody that's watched this, thank you. We hope it's been informative. There is a slide at the end of this presentation that gives contact details for both myself and Sabina. So if you have any questions arising out of this presentation, please do feel free to get in touch for a chat, something informal, or if you're interested in any of the services that Sabina has to offer, just let us know. Thank you for joining us.
Thank you.